Okay, good afternoon, everyone. Welcome to this webinar. Uh, I'm the moderator, Vol Chen. I'm also council member of the Hong Kong Institute of Arbitrators. Well, let me first introduce our speaker. Our speaker, Mr. Li, Li Lianjun. He is a senior partner of Reed Smith Richards Partner and head of the Transportation Commercial Litigation Department of this firm. Uh, he qualified as a solicitor in Hong Kong and England. He has extensive experience in dealing with legal issues, disputes relating to international trade, commercial transactions, um, transportation, shipping, cross-border investments, shareholder agreement and bond issuance, litigation and arbitration. He is also an experienced international commercial and maritime arbitrator himself. He is a panel of arbitrator listed in many well-known arbitration institutions. Mr. Lee has been recognized by Chambers and Partners Legal 500 and Who's Who Legal as a leading individual for many years. Well, of course, we like to welcome Mr. Lee to start this webinar without ado. Let me remind all of you here, in relation to this webinar, the, um, the CBD points uh, will be approved by the Law Society, and the webinar will be recorded. And of course, if you have any questions, please type your questions in the chat box so that Mr. Lee and I will take care of them accordingly. Okay, without further ado, let's give a round of a warm applause to welcome Mr. Lee. Thank you, Mr. Lee.
Thank you. Good afternoon, ladies and gentlemen. It is my great pleasure to meet you all at Zoom. I would like to take this opportunity to thank Hong Kong Institute of Arbitrators for its kind invitation to me and to give this presentation today. I also, of course, thank Ward Chen for his kind introduction. Many thanks also go to Margaret Yip for her kind organizing of this event. My presentation will consist 3 parts. The first part is introduction to Hong Kong shipping law. I hope that this will give an overview on Hong Kong shipping law to those particular who have not extensively dealt with the shipping law in Hong Kong. Secondly, I would like to discuss the latest developments in Hong Kong case law. For those cases, you can see how the Hong Kong court develops the Hong Kong shipping law. So thirdly, I would like to discuss the Ever Given saga. This will give you a flavor as to how a real case develops and how it might affect trade and the law. We shall see how our Hong Kong lawyers and professionals could serve shipping in a real world scenario. So let's move to the first part, introduction to Hong Kong shipping law. In this part, I will give a brief introduction to the Hong Kong shipping industry. And secondly, I will go through Hong Kong shipping law. And thirdly, I will discuss in shipping law we call dry shipping law. And finally, I will do a brief introduction to white shipping law. The first part, let's go to the introduction to Hong Kong shipping. Hong Kong shipping. Hong Kong is an international maritime hub. As you probably know, according to the Baltic International Shipping Center developed index in 2020, Hong Kong is one of the top 4 international shipping centers, ranked after Singapore, London, and Shanghai. The Hong Kong Shipping Register has ranked number 4 in the world, providing quality services to over 2,500 vessels with a gross tonnage over 110 million. What does this mean? This means the vessels flying Hong Kong flag, altogether 2,500, are sailing around the world to serve shipping trade. As you probably also noted, BIMCO, the Baltic International Maritime Conference, has included Hong Kong law and arbitration as one of the 4 standard arbitration options in its standard law and arbitration clauses last year. So what does that mean? If you do shipping or trade law, you will regularly, or you will often see the standard contract which are published or drafted by BIMCO. Then there is a standard law and arbitration clause, and altogether 4 are automatically built in the system. One is English law and London arbitration, and the other one is New York arbitration, US law, and then Singapore law and Singapore arbitration. And Hong Kong is the 4th choices, Hong Kong law and arbitration. As you know, 90% of world trade is carried by ships. So BIMCO standard contracts really serve all the international shipping. Now, Hong Kong is one of the choices for Hong Kong law and arbitration. And probably you also know BIMCO's current chairman is Sabrina Zhou, the past chairman of Huaguang Shipping in Hong Kong. And in Hong Kong, we have also Hong Kong Maritime, and the Port Board was set up to promote the development of the shipping industry in Hong Kong. I have been the member to Hong Kong Maritime and Port Board since its establishment in 2016. This is the Hong Kong port. Probably if you go to the airport, you will pass the main terminals, container terminals in Hong Kong. We have Asian Container Terminals, COSCO HIT, and HIT Modern Terminals. In Hong Kong, if you do shipping, you will know one of the important player is P&I clubs. They serve the ship owners and as indemnify their liabilities to third party. Internationally, there are, it's called International Group of P&I clubs. There are 13 members, 13 clubs. Out of 13, 12 clubs have their offices in Hong Kong. And the China P&I is not an IAG member, but they do have P&I club in Hong Kong. So from the ship owner's point of view, to serve the ship owner on their liability to third parties, I will address later. We have all the international, most important clubs in Hong Kong. Swedish Club, Scoot, American Club, Guard. Guard is a P&I club in Norway. Scoot also in Norway. Standard Club is in England. Steamship Mutual, England, UK P&I. London P&I, Britannia, West England, North England. So all they have offices in Hong Kong to serve Hong Kong ship owners. And all the major maritime insurers and insurance brokers they have offices in Hong Kong. Specialized maritime law firms, lots of international maritime firms they have offices in Hong Kong, like my firm, Inces, Holman Fanwick, Stevenson Harwood, Watson Farley, Klein & Co., Hill Dickinson. They have offices here. And other services like surveyors, experts, like they have offices here. So in Hong Kong, we are in a very unique position. We have all the services of lawyers and service providers. Now, coming to the shipping law, Hong Kong shipping law, I would like to give you a very brief introduction on the sources of Hong Kong shipping law. Of course, basic law after 1997, that is a basic law. And then on the shipping side, we have domestic legislation. Of course, have a case law. Then we have international conventions and the treaties applying to Hong Kong SAR. Domestic laws relating to shipping, like port control, pilotage, merchant shipping, dangerous goods, insurance. We have all the necessary domestic legislations. Most of the domestic legislations are based on English law. And case law, of course, similar with other branch of laws. We have, in Hong Kong, we have Admiralty Court in Hong Kong as part of the Court of First Instance. Of course, Court of Appeal and the Court of Final Appeal. District Court also deal with certain cases below the High Court limit. And international conventions in shipping play a very important role. Hong Kong has been participated or is a party to most of international maritime conventions. For instance, the first one, the Convention for Unification of certain rules of law with respect of collisions between vessels, and the International Convention on Load Lines. So all those conventions were adopted by international organizations, including United Nations or the specialized agency, International Maritime Organization. And after 1997, Hong Kong SAR as an observer and a part of the Chinese delegation to the International Maritime Organization. And some international conventions only apply to Hong Kong, not to the mainland. And Hong Kong, as I said, adopted most modern international conventions. I will deal with cross-border claims later. You will see how that is different from other jurisdictions. Now, after the sources of Hong Kong shipping law, we come into the Admiralty jurisdiction and the ship arrest. And if you have a claim, we call it maritime claim, and you can enforce or you can recover your claims either in personam or in rem in Hong Kong. So if you have a maritime contract, for instance, charter party or bill of lading claim, and you can proceed to in rem against a vessel. This is important, and you can arrest a vessel as a security before obtaining a judgment. So if the ship is under arrest, and that will put commercial pressure on the ship owner because they can't use the vessel during the arrest. So this will also cause the ship owner difficulties with charterers, shippers, consignees. And the ship owners will not receive money if the vessel is under arrest. So they may lack cash flow. So therefore, they may breach the contract to deliver the cargo to the ship owner. So therefore, this is a very important weapon for if you have a claim against the ship owner, you do arrest the vessel to get a security before the trial of the claim. So if the vessel is under arrest, normally you put up security. You can ask your P&I club to put up a security. As I mentioned before, in Hong Kong, the international group, 12 of 13 international group of P&I clubs, and they have offices in Hong Kong. So P&I club may provide security in the form of a letter of undertaking to pay any successful claim. And normally the claimants will accept P&I club letter of guarantee or letter of undertaking. Sometimes a bank guarantee has to be given because the matter may not be covered by the P&I club. If the ship owner can't put up a security through the bank or their P&I club or other institutions, and the ship may remain under arrest indefinitely or until sold to satisfaction of the claim. So how do you start action in rem? And the claim has to be within the Admiralty jurisdiction. So Hong Kong Admiralty jurisdiction can mostly be found in sections 12A to 12E of the Hong Kong Court Ordinance, implementing the Arrest Convention of 1952. So this means the Hong Kong courts will construe local legislative provisions relating to the arrest vessels in rem constantly with the Arrest Convention 1952. The recent case, the Oriental Dragon or the East Cheshire. However, if the wording of the legislation, the High Court Ordinance is sufficient, you don't need to refer to the Arrest Convention. So if you have action in rem, what does that mean? Which means an action against arrest. What does res mean? Res means a thing, a matter. So a res is usually a ship. So you started an action against the vessel. But sometimes it can be cargo, freight, aircraft, or hovercraft. So a res can be arrested if it is within the territorial jurisdiction of the court for maritime claims. So in Hong Kong, 3 miles territory water. And for what? For maritime claim. So maritime claims can be divided into 2 types. One is statutory rights under the law, or maritime liens. So a list of statutory rights is provided under Section 12A, subsection 2 of the High Court Ordinance. And Section 12B of the High Court Ordinance provides all the statutory rights listed above can be enforced in personam, i.e., you make a claim against the ship owners. And then the most statutory rights, except for Section 2A, subsection 2D, and to 12A, 2S, and they can be enforced in rem, i.e. against a vessel. And there are conditions set out in Section 12B, and you can arrest also a sister vessel. What does that mean? If you hire or charter, we call charter a vessel, vessel A, and then if a ship owner has another vessel B owned by the ship owner, so you can arrest B for the claims against A. It's called sister vessel arrest. And the maritime claims, however, if you proceed an action for maritime claims, you have to find exactly what are the claims are. Claims for insurance premium, and they are not maritime claims. If you insure the vessel, marine insurer, if the owners do not pay the premium, you can't arrest. You have no right in rem because they are not statutory claims. The Oriental Dragon, that's the case. It is our case. We represent the ship owner defending certain claims from the ship manager. And in Hong Kong, the ship management gives a claim under the case law Oriental Dragon. In other common law jurisdictions, you may not be able to arrest a vessel based on the ship management contract. In this case, the Hong Kong court decided the ship management services the similar as goods and materials. So therefore, the ship manager can arrest the vessel for the unpaid management fees. That's the statutory rights. Say, if the ship owner owe you money and you check whether you have statutory rights to start action against the vessel, arrest the vessel. And maritime liens, what does that mean? Maritime lien means for those claims, you don't have contract and they are not statutory claims. You can also arrest vessels for those claims, and maritime liens also running before other claims, including mortgage. As you probably know, if a ship, the ship owner borrowed the money, they may mortgage the vessel, and maritime liens are the first priority claims if you arrest vessel. Now, under common law, the maritime liens would have priorities damage caused by a vessel. say if the vessel collided another vessel and the damages caused by the vessel will be maritime lien, ranking before other claims. Salvage, and for those who are not familiar with salvage, if say a vessel is in danger, there's a need to save the vessel, and then you render services, and you are entitled to claim a compensation. So this is different from the land law. Let's say if you on the way someone need you to help, so you normally can't claim for remuneration for such services unless there's a contract. But shipping, salvage of vessel, and property, they are entitled to claim and rank before other claims. Then maritime lien seaman's visit, let's say shipmaster and crew, if the ship owners owe the money, salaries, so their claims will be in front of other claims. Then master's wages and disbursements. And in shipping law, master always treated differently from other crew. The master will be and is, we say, next to God on the vessel. He's the number one in charge, so he has a special right. If the vessel need to borrow money, the master is entitled to do that. So those borrowing by the master will be ranking before other claims. Then you have old Baltimore means borrowing money. And so that's normally is the maritime liens. So they are running before other claims. And for the shipping lawyers, as I mentioned before, if you have a claim against the ship owner, you can arrest the vessel in Hong Kong. So the Admiralty jurisdiction of the court of first instance business, you can revoke the action against the vessel and Hong Kong Admiralty jurisdictions. And in actions commenced in Admiralty list, there is option to pursue a claim by using either in personam or in rem rate. And in an action in rem is against the vessel. As previously mentioned, res usually is a vessel. And if you can always also claim against the cargo on board and the freight, aircraft, or hovercraft. So in order to arrest vessel, as I mentioned before, you have to check whether the claims are within the Admiralty jurisdiction. So the claim must fall into one of the categories of the claim in section 12A mentioned before. And in Hong Kong, we are running 7 days, 24 hours system. If you want to rest vessel, and you can make appointment with the duty judge anytime during the day and the night, and you prepare the paper, you send to the judge, you meet. If after working hours, you can go to the judge's home or whatever the place where she or he is, and he will sign the arrest paper. Then you notify the bailiff. The bailiff will advise the Marine Department and then go on board arrest vessel. And similarly, you can release the vessel 24 hours, 7 days, anytime, any day. So Hong Kong is a very friendly jurisdiction for the ship arrest. In Asia, Hong Kong, Singapore are the best jurisdictions for arresting vessels. That's Admiralty jurisdiction. If the claims are within the jurisdiction, you can arrest vessel for the security. If the ship owners are not able to put up security, you can sail the vessel. Now, in shipping law, we have traditionally divided two sets of rules. One is we call dry shipping, which means on land, contract matters. For instance, carriage goods contract we call charter party. So you have a dispute on the charter party, and we have ship financing agreement, and or carriage goods by sea contract, or I use the vessel, I time charter a vessel or bareboat charter. I will introduce later. And white shipping, which means there might not be pre-contract. For instance, ship collision, the two ships collided each other. You probably remember a few years ago, there was very serious ship collision, Landmark 4, collide with another vessel during the National Day. And so I think 40 people died. So, and that ship collision is we call the wet shipping or salvage, as I mentioned before. If a vessel needs to be rescued, you have the law for salvage. So you are entitled to have the remuneration. General average is in shipping. If you do the international trade, you will know the general average, which means when the ship is in casualty and they need to do something in order to rescue the vessel and the cargo owner, and you spend money or suffer sacrifice, for that part, cargo and the ship contribute for such losses. Pollution, and then you have a limitation of liability. So in shipping law, we divide the dry shipping, basically contract, wet shipping is casualty related. So dry shipping, as mentioned, contracting matters in shipping industry, for instance, charter party, ship financing, shipbuilding, carriage of goods by sea, or use of vessel, time charter or bareboat charter, this kind of concept. So in dry shipping, one of the most important part is bill of lading. If we do international trade, trade finance, or banking law, bill of lading is one of the important area of shipping law. So this is an example of liner bill of lading. So bill of lading function is a receipt of goods shipped. So it means carriers, I acknowledge cargoes in this bill is under my custody. And then it is evidence of the contract for carriage. So bill of lading contains terms of the carriage. In shipping law, we see the terms in the bill of lading is a piece of evidence for contract for carriage. The reason why we see evidence of contract for carriage, there might be other contracts, underlying contract, before the bill of lading issued. And then most importantly to international trade, bill of lading is a document title to the goods. In shipping law, we call it a key to the warehouse. So the bill of lading signed by the shipmaster, and if you international trade and you open the LC at the buyer, and the seller present the documents for the title of goods, is bill of lading. So the bill of lading is very important for the ship in the shipping law. And the dispute involving bill of lading, normally, if the cargo damaged, let's say the cargo arrived, then you found cargo damaged. Then if the cargo loaded is a dangerous cargo, then the vessel exploded, you have seen a lot of casualties. So that will be due by the bill of lading terms. And then you have a dispute between buyer and the seller in respect of goods carried by sea. So that's another side of dispute. And between bank and shipper, the bank as a security, they have bill of lading, and then there might be dispute there. So the most important law relating to bill of lading is International Convention. It's called Hague-Wisby Rules, because originally the International Convention was passed in The Hague, and then this rules are mandated in Visby in Sweden. So it's called Hague-Wisby Rules. Hong Kong is a party to this international convention. So Hague-Wisby Rules will apply, including the bill of lading issued in the shipment port. For instance, if we have cargo loaded in Hong Kong, the Hague-Wisby Rules will automatically govern the transportation, the law relating to the bill of lading. Let's say bill of lading, if the carrier received the goods, issued the bill of lading, and the Hague-Wisby Rules will be governed because Hong Kong is a party to the convention, and it's compulsorily applied to the shipment from Hong Kong. So many countries are party to the Hague-Wisby Rules. Mainland is not, but adopted most of the Hague-Wisby Rule Convention. Now in shipping, if you deal with the international trade, one of the popular bill of lading is called Kangjin Bill. As I mentioned before, BIMCO issued many standard forms. One of the standard form bill of lading is called Kangjin Bill. So in this bill, Hague rules or Hague-Wisby rules will be govern the terms of the carriage if the cargo loaded in those countries, or you choose those laws. So the Kangjin Bill is one of the regular Euro bill of lading for the bulk cargoes. So very briefly, under the Hague-Wisby rules, ship owner have to exercise their duty of due diligence in furnishing a seaworthy vessel. And from where, well, not all the time, before and at the beginning of the voyage, and you have to make due diligence and in seaworthiness, make a seaworthiness vessel. So you can't delegate your obligation to other people. And ship owners, under the Hague-Wisby rules, you have duty to properly and carefully care for the cargo. So properly and care the cargo, not being negligence. So that you have to exercise due diligence. But the carrier's obligation is not absolute. You do your due diligence before that at the beginning. You have to make the vessel seaworthiness and then properly care and for the cargo. However, if some events happen and the carrier or the vessel shall not be liable, So we called except perils. So let's say act, neglect, or default to the master, marine pilot, or the servants of the carrier in the navigation or in the management of ship. Let's say if the vessel collided with another vessel, causing cargo damage due to the fault of the master, and the damages will not be liable by the carrier because that's the default of the master. This is this is a 1968 law. The reason is the master you can't control by the ship owner. It's far away. There are many perils of sea. So this is one of exception. Fare. If there's a fare on the vessel, the damage or whatever, the ship owner or carrier are not liable unless caused by the active fault or privity of the carrier. So you have all the exemptions, 17, say act for good, act of war. The reason is the law or international convention is trying to balance. One is to protect the cargo interest. The other one is to encourage shipping, encourage people to invest in shipping because there are perils for sea. So under the Hague-Visby rules, any clause lessening the carrier's liability will be void. So that's the minimum requirement. So that's bear in mind. Of course, as there are some matters which are not regulated by Hague-Visby rules, like loading and unloading the cargo are not regulated by the Hague-Visby rules. So that's the Hague-Visby rules. Then, as we mentioned, the owners should exercise due diligence, make the vessel seaworthiness before and at the beginning of the voyage. If you don't do so, and unless, as we mentioned, you are accepted, you will be liable. However, the carriers is entitled to limit their liability. And on what? The Hague-Visby rules provides, unless the nature and the value of the goods have been declared by the shipper before shipment and inserted in the bill of lading, neither the carrier nor the ship will be liable exceeding 660.67 SDR. SDR is the money unit per packet, or 2 units per kilo. So therefore, the ship owners can enjoy the package limitation. So you see, shipping law gave ship owner or carrier a lot of rights, including exceptions, the limitation of liability. Basically, is encourage people to invest in shipping. Time bar, I would like to mention that under the bill of lading contract, if you have a claim against the carrier, it's 1 year, not normally 6 years. However, if the carrier claiming against the cargo interest holder bill of lading, it will be 6 years. So that's the bill of lading, very important. And the second important contract is called Voyage Charter. Like if you hire a car to transport goods from Central to Causeway Bay and pay driver a fee for the carriage of the cargo, is Voyage Charter. Again, a lot of cases relating to the carriage of goods. Standard Voyage Charter is Changhong, is published by BIMCO. As mentioned before, Hong Kong is one of the 4 built-in jurisdiction for maritime arbitration. So the parties can choose Hong Kong as one of the place of arbitration. And as mentioned, if you charter the vessel for carriage from, say, Hong Kong to Guangzhou, and then carriers will limit your time to load or discharge, and it's called lay time. If you exceed lay time, you pay demurrage. So in the voyage charter, you have these kinds of claims, a lot of dispute as to how to calculate lay time, how to calculate the demurrage. A typical dispute is amount of demurrage and breach of warranty of safety. Time charter. If you have a lot of cargoes, I would like to hire a car to transport goods from Central to Causeway Bay. However, I will pay the fee based on time engaged basis. It's called time charter. You pay the hire of the vessel. And the standard form is NYPE. Lot of dispute regarding the time charter, like speed consumption of hire. And have famous Hong Kong fur case, a lot of dispute on the time charter. Because the time limit, I will quickly let you know what it is. Demise charter. If you are investor, you want to invest vessel, you rent out your vessel, and the charterers, i.e. the lessors, they will pay your fees, and you don't have crew on board. So basically, investor do that. If you are a ship owner, you don't have money, and you charter the vessel like you rent a car. So you drive yourself, you do whatever you wear, then you pay the fees. A lot of dispute on the demise charter. And other shipping contracts, like shipbuilding contracts, towage. So if your vessel has a problem, you want to tow the vessel, you have a towage contract. If you appoint shipping agents, you have ship agents contract. And you have supply, finance contract, maritime insurance, PNEG club rules. And if you berth, discharge cargo, you have terminal contracts. And I'm a ship owner, I don't need have crew, so I have crew manning contract. Then I want someone else to do the technical management, so I will have the ship management contracts. And I use broker and ship brokering contracts. And I use people running my company, they do charters, so I have commercial management. Of course, a lot of joint ventures. And I think, Samuel, your family, you have shipping before, you have joint ventures with other people. So a lot of matters relating to the shipping contract. So that's very briefly on the dry shipping. Then, as I mentioned, you have white shipping, you do the casualties, like ship collision, accidents related, you have salvage, you need to save the vessel. So you have, if you successfully rescue the vessel, you will be awarded general average, as I mentioned before. And if the vessel, in order to save the vessel, some cargo may be jetted, maybe slew away on the water, then there is a loss. Let's say ship and other cargo interest contribute to this is called general average. If we do shipping or trading, that's very often seen, you contribute certain expenses. Then you have ship collision, pollution, and that's all the casualty part. And again, there's a limitation of liability regime that encourage people to do the shipping. So the limitation will be based on normally on the tonnage of the vessel. And it's called limitation of liability. So that is also important part of the of the maritime law, as meant ship collision, a lot of cases, the vessel sailing around the world, and why the sea is too big, why the vessels still collide each other. You have very modern technology. 90% of ship collision caused by the human error, by the fault of judgment by the crew members. And you have pollution. If the vessel loaded crude oil, whatever the oil, then grounded, you have oil pollution. So you have a lot of international conventions in Hong Kong, and there are a lot of laws and regulations govern pollution and environmental damage. So the casualty lawyers will deal with all the claims. As I mentioned, the limitation of liability, in order to encourage people invest in shipping, and there are limitations of liabilities, is based on normally tonnage of the vessel. And so in Hong Kong, adopted the latest limitation convention, limitation of liabilities. There are basically based on the tonnage of vessel. For personal injury, if people died, there's a limit based on the tonnage. And if you have property damage, if say ship collision, so you have property claims under the limitation. Passenger claims, time limitation. So that's basically the white law part. And hopefully I have given you some ideas on shipping law, contract part, and casualty. If you are interested, you can read my PPT in detail. A lot of areas. Hong Kong, as I mentioned, one of the shipping center. We need a lot of people, specialized in shipping, so we can serve the industry. As I also mentioned, Hong Kong is the fourth largest shipping register, 2,500 vessels sailing around the world. So we need get the ship owners to use us. Now, because of time, I will very quickly give the latest 3 cases. They are very important in shipping law. Those also gave the precedent to other common law jurisdictions. One is Sanchi tanker CF Crystal and Sanchi. In this case, in January, on the 6th of January 2018, a Panamanian flag vessel, Sanchi, collided with a Hong Kong flag vessel. The cargo on the Sanchi was condensed oil. And immediately after collision, and the Sanchi caught fire. 30 crew members were missing, not survived. So 3 bodies found. So the claim from Sanchi of Sanchi sinking, and about 110 million US dollar, 60 million is for the cargo, 50 million is for the vessel. Now there are crew claims, something like 11 million. So the Sanchi commenced proceeding in Hong Kong against the CF Crystal because the owners are registered in Hong Kong. And the cargo claimed against Sanchi for 60 million. And altogether, now probably 150 million US dollar claim. And the casualty happened about 160 nautical miles off Shanghai. It's about 300 kilometers of kilometers from Shanghai. And mainland China sent a lot of rescue efforts, and the vessel finally sank. The pollution was reduced. So CF Crystal commenced Chinese proceedings in China and set up a limitation fund. As I mentioned before, ship owner can limit liability. And the Sanchi owner started action in Hong Kong and claim against CF Crystal. And in this case, we act for CF Crystal interest. What the case is about, and our clients, CF Crystal, and filed challenge the jurisdiction of Hong Kong court in favor of Shanghai Maritime Court because its most activities were taken in Hong Kong, in Shanghai, and also the CF Crystal also set up the limitation fund in Shanghai. So we applied, we challenged the jurisdiction. And the High Court Hong Kong decided the court's first instance dismissed the application. However, the leave was granted to appeal. We understand that it is almost 17 years High Court judges normally do not grant leave to appeal. In this case, the court first instance grant leave. However, the court appeal upheld the first instance court jurisdiction. So basically, the Hong Kong court applied 1986 cases. So the applicant, i.e. our clients, have to show there's some other available forum, and the applicants should show Hong Kong is not the natural appropriate forum, and there's another forum which is clearly or distinctly more appropriate. And the respondent, the other side, should show he will be deprived of the legitimate personal or judicial disadvantage. So the court will balance of the alternative forum with the disadvantage the respondent may suffer. So the court decided, although Shanghai Maritime Court has jurisdiction to deal with matters in China, and also limitation of liability has been established in China, so Hong Kong still has jurisdiction. And although the incident occurred in the EEZ, however, this will not apply. It's a sovereignty right rather than a normal shipping claim. And tonnage limitation, Hong Kong is 3 times of limitation applied in mainland. So therefore, the application to stay Hong Kong proceeding dismissed. Then our clients tried to get a CFA final approval to the CFA. However, the leave application was rejected. So this is a latest law in limitation, in jurisdiction challenge. It's very important law, in particular the cross-border dispute. The second case is called Antea and Star Centurion. This again is important law on the limitation of liability. We act for Antea interest in this case. So we applied for, the issue relating to how to interpret the International Convention. So on the 13th January 2019, Antea collided with the Star Centurion in Indonesia. Then the vessel sank. The question is whether our client is registered in Hong Kong, whether entitled to limit for liability. Again, as you see, limitation is very important. The Hong Kong is a party to the party of the 76 Convention. So whether the issue is whether the wreck removal will be a claim under the limitation. And when Hong Kong adopted the limitation, the relevant ordinance provides, subject to this part, the provision in 1976 in Schedule 2 have the fourth law. Then the chief executive may, by order, provide any fund for the harbor or authorities in order to remove wreck whatsoever. And if the fund had not been established, and the wreck removal in the convention will not apply. So that's under the convention. Say the claims in respect of loss of personal injury, damage to property, and on board the director operation of ship can be limited. Then clause D, claims in respect of rising, removal, destruction, and rendering harm of ship which is sank, wrecked, stranded, or abandoned, including anything has been on board the ship. So under the convention, all those claims can be limited to a certain amount under the convention. However, when Hong Kong adopted this convention, there was a reservation saying for the item 1D, the chief executive can set up a special fund in those claims. But before setting up that, those claims are not limited. D, i.e. D excluded. Our clients argue that the wreck removal should fall into clause A because this damaged property, harbor work. So you'll see when the international convention is drafted, there are overlapping. But the first instance court decided that, reading the whole convention as a whole, and the wreck removal should not be limited. So this case is under the appeal. It is very important for Hong Kong court to develop the way of interpretation, because in other common law jurisdictions, we don't have a case for reference. So we will wait for the court pivot judgment. Hopefully this will also contribute to the maritime jurisprudence in the world. So that is second case I would like to draw your attention. Third case is under the bill of lading case. In summary, a Hong Kong court maintains the previous law, previous English law. If you have bill of lading, unless the bill of lading terms expressly incorporate the Charter Party arbitration clause, so the Charter Party arbitration clause will not apply. So this is will be important for people doing banking or international trade. If you have bill of lading, and then bill of lading is not clearly incorporating arbitration clause, you have to decide where you start claims. So you have time, you can read the case, very interesting. So that's the three cases, all are very important cases to shipping and to the maritime jurisprudence. And that is the shipping case. The last one, because the time is running out, you have probably heard the case affecting lots of people, trade, and this Ever Given case. And Ever Given is one of the largest ship container vessel. The ship was built very new, delivered in 2018. So the operator is Evergreen Line. They time charter the vessel, as I mentioned, the time charter, from the ship owner in Japan. And the insurer, P&I, for the owner's liability is UK P&I, classification ABS, shipbuilder is Japan, the ship manager, technical manager is in Germany. Okay, the last port the vessel visited is the Antea. Okay, so that's the case. Now on 23rd March 2020, when the ship passing through the Suez Canal on its way to Rotterdam from the port, then is stuck near the village, then blocked the channel. And finally on 29, the vessel refloated. So the Suez Canal is the most important trading route, which was opened in 1869. So 2020, 12% of the global trade passing Suez Canal. So the vessel grounded, and then a lot of international trade is affected. And the 12% of trade affected, and the parties involved, ship owner, time charter, evergreen time charter vessel, and you have technical manager. The management by Bernard Schutter is one of the famous ship manager. P&I clubs is UK P&I clubs, so they will be involving in dealing with the claim. Then the vessel grounded, you need a salvage. So the salvor is a Smith salvage and the Nippon salvage. They do the vessel salvage. Then the average adjuster saying, okay, because your expenses, salvage, and to save the vessel, so you cargo interest and ship owner needed to contribute the cost of saving vessel. So general average adjuster appointed. So the party involved, cargo owner, I have cargo on board, I need to deliver. So therefore I will look at with whom or to whom I can claim. So I have bill of lading, maybe issued by the time charters, evergreen, then have owners for container, then slot charters. What does that mean? Means the other liners will use this vessel. So we have clients in structures to deal with the slot charters against evergreen. Then evergreen, they running the line, they time charter in, they issue the bill of lading. So therefore, they have a claim with the ship owner because the vessel grounded, they can't transport the cargo. And then you have ship owner's liability. And so finally, the vessel arrested by the authority after successfully lifting the grounding, and security put up $500 million US. So a lot of cases are still going on because the delay of delivery, because the grounding, a lot of dispute involved, a lot of Hong Kong shipping firms involved. So that is very interesting case. And you can think about if the vessel was built in China, if the vessel was managed or chartered by a Chinese liner, that may make things more complicated and different because the current international environment. So that's very briefly, I would say in Hong Kong, most lawyers, surveyors, average adjusters involved in this matter. We have all the service professionals to serve the industry. So in summary, very briefly, I have given an introduction to the Admiralty jurisdiction and the ship arrest. And I have covered dry shipping, basically general introduction, and the wet shipping, and the latest development on the shipping cases, 3 cases. And then I would like to remind people today, I'm a shipping lawyer. I welcome you participate or in the shipping professional, we need many people, professionals, lawyers to engage. We are one of the 4th international shipping center. We always compare with Singapore, and because Hong Kong is close to the mainland, the largest one, the 2nd largest economy, and we will have more opportunities if we compare with Singapore. Of course, Singapore is very pushing. The government and the industry are doing their best to attract people coming to Singapore. Thank you very much. Hopefully, I can you will have some benefit to learn the shipping law. Thank you very much. Thank you. Any questions?
Thank you so much, Mr. Li. Of course, I encourage participants, you put down your question in writing into the chat box, but I think I can't wait. I just like to
Thank you.
sound out loud my particular question. As we all know, as you said, Hong Kong is one of the leading maritime arbitration center in this respect. What do you think? How Hong Kong? What things we can do in order to enhance Hong Kong's status as a maritime arbitration center in this sense?
Yeah, thank you very much. It's a very good question. As I mentioned, very good news last year. BIMCO, the largest shipping organization, chose Hong Kong as one of the 4 built-in dispute resolution place. So we need, like today's seminar, we need a lot of young people. We need shipping. We need lawyers specialize in shipping or participate, and we need training. Currently, of course, number 1 is London, because you have court shipping lawyers, barristers. In Hong Kong, we don't have many barristers in shipping. And now we have very good opportunity. We are next to the mainland. It's the 2nd largest economic, everyone does business with China. So we need to educate those users and choose Hong Kong. And we, of course, we need a lot of professionals and to serve the trade. Yeah. Ms. Chen, I can't hear you. You mute. Yes. What?
Yep. Yep.
Yep.
Yeah. Well, Mr. Li, you can hear me now, right?
Yes.
Well, while we are talking about mainland China, well, I think nowadays we all talk about the Greater Bay Area. How Hong Kong can take advantage, leverage our neighbor, the Greater Bay Area initiative to enhance maritime arbitration industry in Hong Kong?
Yes, I think the Great Bay Area is another opportunity for Hong Kong professionals. And in particular, I think we should encourage, continue to promote Hong Kong maritime services, to serve the shipping companies, the traders. You see the next in Yantian Port is the largest single port in the world for cargo. It's the number 1. Shenzhen is a single one port. That's the largest port. You have a lot of export in the Great Bay Area. You have shipping companies, and we really need either from government, from the organizations. We need do the promotion. And why not choose Hong Kong? We have language skill, the legal system. Why you go to London or Singapore? Hong Kong is probably the best place.
Okay, thank you so much, Mr. Li. I can see the time, even though I still have many questions I wish to ask you. Well, unless Mr. Chairman Samuel, you have other things that you'd like to ask Mr. Li, I just don't want to occupy his time too much in this respect.
Thank you, Lianjun, for
Okay.
giving this talk. It is very informative, and we will express our thanks to you again. And any questions that attendants have, and we see a lot of participants today, you can put it in writing to us, and we'll try to pass it to Mr. Li.
Yes, yes. Okay. Thank you so much, Mr. Li. I really appreciate your insightful sharing. Thank you. Thank you. We really appreciate it. Thank you.
I got one question. I think that, yes. Okay. This is climate change and the carbon, emission reducing. This is one of the topics in the shipping industry, and we want to achieve the goal. I think the bank, the industry are working together now, and a very good question. Hopefully, Hong Kong will take the lead. I have spoken with the banks. The industry now is really active to reduce the emission of carbon, whatever environmental aspect. Thank you very much.
Good. Thank you so much again, Mr. Li. We really appreciate your time and your sharing. Thank you so much.
Thank you. Bye now.
On behalf of the audience, thank you. Bye bye.
Thank you. Thank you.
Bye bye.
Bye bye.